Thank you so much, Katerina, and thank you for the invitation to address you. So, a lot of what I'm going to say today will actually build on some of our panel remarks yesterday, but I don't know, can I solve the problem of fraud and cryptocurrencies, but certainly we can talk about the regulatory frameworks. And I will maybe just talk for about 15 minutes and then leave a little bit of time for questions, because I think the questions are probably the most engaging part of it. So I'm going to talk about emerging tech and criminal law from a European and global perspective. And we talked a bit yesterday about how, I suppose, AI is often used as a synonym for technologies at the moment. And actually, ironically, I will be talking about AI quite a lot. But it's also really important to recognize that there are many other emerging technologies. And in particular, quantum computing, I think, is one of the things that we do need to think about quite a bit. So I've got a fantastic graduate student looking at quantum computing and criminal law at the moment, particularly around encryption. So I think it's important for us not to just think about AI, but also think about other forms of emerging tech. So today's talk, I don't know how many of you are experts in AI or AI regulation, but as I said, I've kept it reasonably general because I wasn't sure what the audience would be like, but certainly we can get into more discussion around when we have questions. So as we've heard in our presentations yesterday and today, so AI has many uses in relation to blockchain, optimizing how data is processed and managed, and also enhancing security. But as Katerina said at the start, AI is also extremely useful to bad actors who would do fraudulent things, who would do hacking, etc. So what I'm going to talk about today is about the regulatory framework in relation to emerging tech, particularly across Europe. And I'm going to talk about some of the key issues that we need to think about. And I come from this very much as a criminal law background, but I think it's important for every type of lawyer or regulator to understand these things, particularly those of us who come from a private law perspective. So if I had my slides, I would give a definition of AI. But this has been one of the things that has happened or has been quite a difficult issue in relation to defining and regulating AI, which is what do we actually mean by AI? So AI is a term that ranges from really simple algorithms that might be even paper-based systems, a checklist, up to incredibly complex systems. So I think someone mentioned yesterday about agentic AI, which is one of the new things that we have started thinking about, where essentially you're giving over control of a process to an AI system. So this could range from something quite benign in relation to asking an AI system to plan your trip to Rome, to something that's very complex. So in many cases, AI systems have evolved to the point that they are opaque and highly complex, which when we think about regulation and when we think particularly about fundamental rights and our ability in law to be able to understand how a decision is made, this is one of the complexities. So in terms of AI systems, we were even talking at dinner last night about some really things that we could do with AI. Stephen, you were talking about, I think, was it your person who used it to do some of the shopping? So we're using it in a very large, or shopping for shampoo, I think, which was fascinating. We're using it in a very large range of aspects of our society. So the recommender systems that seem to govern our lives, our banking, our social media, our LinkedIn contexts, and again, from those very simple usages up to the very complex. So in relation to the regulatory landscape, and we had some really good discussion yesterday with our panel, so we can see that in terms of, I suppose, regulatory theory or how regulation evolves, we have very quickly in the last 3 to 5 years developed a regulatory system for AI and emerging tech, particularly in the EU. But what has also happened is that technology, I suppose, has got far ahead of regulation. And we tried to deal with that in a number of ways. So as I said yesterday, our first wave was, okay, this is really exciting, we can do this thing. And we talked about how we could improve the operation of the technology. So I used the example yesterday of biometrics, which was that we discovered that we could do facial recognition, and then we spent a lot of time thinking about how it could be more accurate. The next phase was when we talked about, we can actually do this now, but should we be doing it? So those ethical conversations, and we can identify humans remotely, but is this an ethical thing for our society to do? And as I said, you very quickly see that the private sector caught up with this, and we saw probably around 7 to 10 years ago a phase where every private company that used technology, and particularly the beginnings of AI, was developing a responsible AI charter. So these were statements that private sector companies would put out to say, you know, we are fair, we are transparent, we have a human in the loop, and we exercise empathy. So that's all very well, but as a citizen who might be impacted by technology in that way, having a really broad, responsible AI charter isn't that much use to you in terms of enforcing your rights. So what we've seen, particularly at an EU level in the last couple of years, is that transition to legislation. So you've all probably heard of the EU AI Act, which came into force earlier last year, but obviously will be gradually implemented up until 2027. And in combination with other existing EU standards, such as the GDPR, and the big legislation last year of the Digital Services Act and the Digital Markets Act, which are not specific for AI, but are really important, particularly in the control of large technology companies and platforms. We've seen that transition to concrete legislation with implications for people who break the rules. But a parallel and really important aspect as well, in my view, is human rights standards. So obviously, emerging tech such as AI impacts on our human rights that are existing and long-standing. So privacy, freedom of expression, etc., are all impacted. But what we've seen as well, and I think my Hungarian colleague discussed this yesterday, is a lot of discussion and public discourse around what I would call red lines in the use of AI. So that question of, and other emerging technologies, that question is, should we as a society prohibit particular types of technology? And as you said yesterday in relation to the law of armed conflict, there's a lot of discussions about whether certain types of autonomous weapons or predictive technologies should be completely banned. We've talked about it in relation at an EU level to, again, that live facial recognition or emotion recognition technologies. Or the idea of social scoring, where we use algorithms to calculate risk scores about citizens. So that is a conversation that is very much live. And so if I had my slides, I would point to the Council of Europe Framework Convention on AI, which was promulgated last year, which gives a basis, again, at a Council of Europe level about the use of AI. And there's a lot of discourse at an international level now about that issue of human rights and technology. So in terms of the EU AI Act, so this was the European project to regulate AI, and I think we talked about briefly yesterday those geopolitical issues that are happening at the moment, and the big discussion in particular between the US and the EU, which, as I said, is really playing out in my home jurisdiction of Ireland, because we have most of the world's large tech companies headquartered in Dublin. Our economy is highly dependent on the tax takes from these tech companies. So my own home area of Cork is very much dependent on the big pharma companies, but yet we're part of the EU. So we can see that really playing out in the Irish situation. You have American companies who have different views on technology. We're seeing the clashes in relation to things like the Apple tax case. Where the Irish government is stuck in the middle of these geopolitical tensions. So I think this area, even though the European Union has moved to regulate AI, as we talked about briefly yesterday, I think there will be more developments in terms of this perceived tension between innovation and regulation. So my own view would be that I think innovation thrives in certainty, where you've got clear rules, where you've got clear boundaries, where you've got, I suppose, innovative forms of regulation like the regulatory sandboxes we were talking about earlier, that provides space for innovation to grow. But obviously there are other jurisdictions who think that loosening controls is the way to go. So we're definitely seeing that in terms of the US government's rollback of the quite minimal guidance that it had around emerging technologies. So the European AI Act, when I talk to my students about it, I say it's basically toaster safety legislation, by which I mean it's essentially a product safety regime, which is designed to protect your fundamental rights, but is very much based on that idea of the liability of the suppliers. So what it does is it creates a pyramid from unacceptable risk, which are prohibited from being placed on the EU market, to minimal risk. So some examples of things that the EU is essentially saying are prohibited would be that social scoring, individual predictive policing, live biometric identification, and emotion recognition in the workplace. So these are things that are essentially banned across the EU now. High risk then would include a lot of aspects of our society, so critical infrastructure, education, employment, and essential public services. And then the limited and minimal risk is everything else. So it operates this tiered risk system, which imposes requirements and liability on suppliers. So as I said, in doing that, it does protect our fundamental rights, but is very much from that product safety lens. Okay, so I'm going to move now to looking at some key risks and challenges in relation to this area of emerging technologies. So we talked a little bit yesterday about bias and discrimination, and so I want to address that a little bit more today. So the EU has, I suppose, set a standard in terms of banning some forms of really intrusive monitoring, particularly of vulnerable populations. So individualized predictive policing, where you create a score for a particular person based on their characteristics, is now banned. Emotion recognition is banned, social scoring is banned. But as we briefly touched on yesterday, this issue of bias, whether you're engaged in a technical process that governs a commercial law process or a private sector database, or something that's on a public sector basis, such as the Siri system, which the Dutch government was using to detect welfare fraud. Bias is incredibly important consideration. So we talked yesterday about training bias, where you run a system which is trained on a particular form of data. So our society, as we heard yesterday, is quite biased anyway. So if you're drawing from that, your system is likely to be biased. So good examples are law enforcement systems, which are contain data from people who are already engaged in the system. So if you've got a biased law enforcement system or a criminal justice system, that's the data set that you'll have. So if that system is used to make predictions, it will use that precedent to generate a risk score. We can then have algorithmic bias, which is where the programmer of the system might make mistakes in relation to the unfair weighting of a particular factor. And then that overall idea of cognitive bias, so that the people who design the technology are subject to their own biases. So these are all important ones. So when we were talking about some of the financial systems earlier, I was thinking again on this theme of how we often think about bias in relation to law enforcement and immigration, but it's also filtering into other aspects of our law. And I was at a predictive policing meeting in the Netherlands a couple of weeks ago, and there was a colleague there who had actually himself got caught up in, I suppose, an anti-terrorism or an anti-drug sweep of financial transactions. And the reason was his nickname for his niece mirrored a term that's used in slang for trafficking cocaine. And he had put in the notes he was sending a birthday present to his niece, and he was caught up with it. And I also had a student who was from a particular background that might get picked up in anti-terror money laundering. And again, he had his computer seized by the police in Ireland, very, very wrongly, but because of a transaction that he was sending money to the family. So again, it's based on particular factors, which may or may not be bias, but it has real implications for people. So in relation to hiring systems is another one that we're seeing quite a lot. So you're aware now, if you're applying for a job, particularly in a big company, the first sweep of your CV is very likely to be done by automated means. If you're interested, there's some really interesting ways to fool the algorithm and embed prompts in your CV to make it do particular things. But it's a real problem in relation, again, to bias, making automated judgments on where that person is from, their address, their name, that can result in real problems. So again, for women and ethnic minorities, if your automated CV system recognizes that your leadership team are from a particular gender or particular ethnicity, it will try and copy that in the predictions that it makes. We're also seeing this in relation to systems like child protection and healthcare in relation to bias. So the second one is privacy. So obviously we are very concerned with privacy, and we've got a really good fundamental framework across EU nations in relation to protecting privacy. But New Zealand, where Petra and I have worked for many years, has a much less comprehensive protection of privacy. So although we're pretty protected within the EU, other jurisdictions, particularly in the global majority countries, have much less protection in this regard. And so as I mentioned, that global conversation as well around red lines in AI, particularly around military uses and uses like emotion recognition technology that can discriminate against people with disabilities in particular, is very much a live issue. So I want to move now to two other, I think, fundamental and cross-cutting issues. And one of them is something that's come up in a couple of the presentations around where do we draw the distinction as a society as to what decisions should only be made by humans and those that should be made by technology. So this can relate a bit towards where we make the decision as well. So we'd be aware that over the COVID period, we suddenly transitioned to having a lot of our justice processes done through a computer or a phone. And of course, policymakers are really interested in that because it's much cheaper and much easier. But this issue of what are we comfortable in relation to automated decisions being made is one of the big issues in relation to regulating emerging technologies. So for instance, in the immigration space, we might be quite comfortable with, when we get a visitor visa for the US, a quick and automated decision based on my risk factors. But we very much would not like, I would suggest, a decision about someone's refugee status to be made by an automated system. But this is a question that's filtering across all aspects of our legal system, from decisions around credit scores or lending, right up to really fundamental decisions around people's lives. And I think a particular area that we've seen happening in Europe would be the border security area, because the EU AI Act is very good on some types of legal decisions, but it almost completely excerpts the border security field. And so we've seen tests of some really concerning automated and emotion recognition systems at the EU borders. And the second aspect, which I think applies quite a lot to the private sector field, is around, I suppose, automatic adjudication. So again, there's some really interesting innovations happening globally and across Europe in relation to automated systems. So perhaps you want to have an automated negotiation system where you agree in advance that you will accept the decision of an AI negotiator or arbitrator. And of course, we've seen tests as well of online courts. So particularly in more minor things like, say, a speeding ticket, where an AI or an automated system would give you an answer on your appealing of the speeding ticket. But of course, I think we'd all agree that we wouldn't like to see sentencing or immigration decisions being made by an automated judge. And as we mentioned yesterday, this move of a lot of our systems, our public sector systems, the move to digital identity, this can exclude large parts of our population. So we heard yesterday about the digital divide, both in terms of access to devices and to the internet, but also the understanding around people having that digital literacy and understanding how these systems work, and the effect on access to justice of people not having the ability to engage with this system. So the last thing that I want to discuss, I suppose, is something that's been coming up particularly for the legal profession, but I think it's important for any regulated profession or anyone in their job, which is about the actual real risks in relation to our professional standards for AI. So those of us that work in universities will see this particularly at this time of the year. So that's something that I need to do later, is deal with a couple of postgraduate students who potentially have used AI without declaring it. But we had a case in the the High Court of England and Wales the Friday before last, which concerned two lawyers who had used AI in their submissions and their work. And unfortunately, what the AI had done was generated legal hallucinations. And so the judge had checked this and they didn't exist. And so interestingly, in the appendix to the judgment, the court went through examples from a number of other jurisdictions. There was even ones from New Zealand that I wasn't aware of myself. So what the court said, which I think is a good lesson to finish for all of us, it said, the idea that the duty of the lawyer or the professional person, that it was like if you delegate a task to a junior person in your office, so a junior lawyer or somebody in your research team, it's your responsibility as the senior person, the responsible person, to sign out that piece of material. So you might use it, as we heard yesterday, as a tool, as a brainstormer, but the responsibility is yours. But what was interesting in terms of the criminal law is that this court in England and Wales reminded lawyers that deliberately placing or negligently placing false material before the court could involve a charge of perverting the course of justice, which interestingly carries in England and Wales a maximum sentence of life imprisonment. So I don't think that they were doing that to those particular lawyers, but I think it was a really good reminder for all of us in our work that we could actually end up with a criminal risk for the use of AI. So I'm going to finish the formal part of my presentation now, but I'd be very happy to answer any questions or create a space just for some discussions and comments if people had them.
Yeah, let's ask.
Yeah.
Any questions? First of all, thank you. May I get your mic, and then you can use this one to answer the question. So here we go with the mic.
Thank you. Very interesting presentation. You raised an interesting point about what kind of questions, what kind of decisions should be made by AI and which ones shouldn't.
Yeah.
But you also pointed out that you have an issue with your own students, that they use AI because it's convenient and then don't say they're using AI. And there is an awful lot of legal cases where there are hallucinated citations because people say AI is so convenient, let's use it. So if we want to regulate where AI is used or where it's not, the incentives of the situation are such that there's going to be a lot of illegal or illicit use of AI, even in situations where it shouldn't be used. Has anybody looked at regulating the incentives?
Yeah, it's a really interesting question, and I think that's, as you say, was clearly the case in that English case, that you had two somewhat junior lawyers who were obviously under pressure. They had missed deadlines. They decided to take a shortcut. I'm not aware of anything specific about incentives, but I think it's not the case of the courts in that case, or I wouldn't say that we should ban the use of AI in legal research, but it's about where the responsibility lies in relation to the final output, that you can use it like any other legal database like Westlaw or anything like that, but you can't come to court and say, oh, Westlaw told me the wrong thing. You have to have the ultimate responsibility.
Thank you. Any further questions? Hier vorne. Nur dann wollen wir doch mal, Petra.
Sorry, and I don't think it's so much a question than a comment to engage, just to see how nuanced I think the decision making is. So as part of the German legal training, I spent a considerable time sitting in the back of a police car. And this is, of course, a long time ago, but I can tell you at that time, if you drove a particular car, you were far more likely to be stopped by police. So bias has been there since, I think, humans. So there is, of course, a chance in using AI to get around that bias, because now we actually do have that discussion in regard to bias far more than we ever had when the police were just doing what they were doing because it went under the radar, basically. So there is actually a real chance to get around bias. And then I have a question around, the same is true for sentencing, of course. You have at least one colleague in Australia at Bond who actually has said that it would be really good for criminal decisions and sentencing decisions done by AI for exactly the same reasons, because the argument is they are fairer and they're more consistent sentencing if you leave it to AI to sentence.
Yeah, no, that's an excellent point, Petra. And I think what I said yesterday, I used the example of error rates in predictive systems, that you'll get people getting really excited about a 1% to 2% error rate, and we like to remind that humans are terrible decision makers. And talking about sentencing, we've got numerous qualitative studies which look at factors such as a judge judging you before lunch, or when there's been a terrible sports result for their team. So I see promise in that as well, of that kind of assistive AI system, that if you could reduce the bias in it, and even we have this quite a bit in the courts already, where we have what might be described as very simple, even paper checklists, particularly around things like giving bail, where you would have a list of factors and a judge would use that to kind of evaluate their decision. If you had an AI system that would help people to look at those particular factors and maybe reduce some of the bias. But I think that wider point, that it's not as if we have a gold standard between human judges and police officers, far from it. Certainly our AI isn't perfect, but perhaps there's a way that we can use AI and other technology to help people to make better decisions. But I think we're probably a bit away from that at the moment.
Any further one last question?
Well, no, I in part because we're going to do a workshop on access to justice and technology this afternoon. This last point, I think, it really bears emphasis, because when we talk about using technology, blockchain, AI, brilliant, we're still talking about using video conferencing as a way to increase access to justice. And one of the reactions we get is this notion that you can't tell a witness's credibility if you're not in the room with them. And this idea of magic thinking, where I can look into your eyes and tell whether you're lying, whether we're in the room, and all the studies show that's not true. And that judges and policemen and prosecutors are really terrible at telling when someone's lying. So one of the things we have to do when we talk about using technology is break the myths that we have this kind of human intuitive nature that is better at finding these things that technology gets in the way of. And so working through those biases, which are so deeply ingrained, is really important.
100%, and I'm involved in an EU-funded project about children's procedural rights and digital justice, and I think there's a large part of that cohort that hold fast to, in-person child justice is fantastic. And I'm kind of like that same thing. I'm like, what courtrooms have you been in recently? Like, where the child is fully engaged and the judicial officer is participating. So I think, we have to have that very pragmatic approach. And I think particularly where we can use good quality technology. I mean, I think it's terrible to sit in a courtroom where the offender is coming in from prison, on a very bad video screen. But some of the technology we have, the person may as well be in the room. So I very much agree with you.